Can you guys hear me?
Yes.
Calling case number 24-01173 SM. This is the people of the state of Michigan versus Len Derek Tyler Stringer. Mr. Engott, do you wish to place an appearance on the record?
Judge John Engott, I'm here as appointed counsel for Mr. Stringer regarding this arraignment. However, Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Len Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, it is charged by the people of the state of Michigan that in this city of Royal Oak, county of Oakland, and state of Michigan, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compile Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. If the victim is a minor, it is a Tier 2 offense. If you have a prior conviction for a Tier 1 offense, it is a Tier 3 offense. If you have a prior conviction for a Tier 2 offense. This is a high misdemeanor, punishable by up to 2 years in the state prison and up to $2,000. Also, a mandatory collection of DNA identifying profiling samples. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compile Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure. At this time, the court enters not guilty pleas on both of these matters, so that Mr. Stringer's presumption of innocence under the constitutions of Michigan and the United States are preserved.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
All right, buckle up, because today's case is not just another sovereign citizen meltdown. This one spirals into something far more disturbing. We're talking about a defendant charged with indecent exposure, allegedly fondling himself in a public space, who then walks into court and tries to argue that he's not even a person. Not the defendant. Not the name on the docket. Not even a human being in the legal sense. No, he claims to be a beneficiary, protecting a so-called estate. But here's the twist. This isn't just courtroom theatrics. This man has active warrants out of Texas for assault and family violence, a history of evading arrest, weapons charges. And now he's standing in a Michigan courtroom asking how you can charge a dead entity. We're about to watch two judges handle this situation in completely different but equally precise ways. One focuses on procedure. The other zeroes in on competency. And by the end of this, the legal strategy shifts from sovereign citizen nonsense to something much more serious. Mental fitness to stand trial. Pay close attention to the bond decision. Pay attention to the competency discussion. Because what starts as internet law cosplay turns into a very real legal reckoning. Let's get into it.
Mr. Engott, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today. If probable cause is either found or waived at that preliminary examination, the matter will be bound over to the Oakland County Circuit Court for further arraignment, trial, and proceedings. The court must now set bond in this manner. That's not intended to prejudge or punish you. You are presumed innocent, Mr. Stringer. However, the court must set bond in order to ensure your reappearance to court and afford any necessary protection for the public. In that regard, the court would first hear from Detective Keith Baringa of the Royal Oak Police Department. Then the court would hear from your attorney, Mr. Stringer. Detective Baringa, please proceed.
Thank you. He currently has 2 warrants out of the state of Texas for assault and Also, in assault with injury to family violence out of Texas. He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying information or government documents. I'm not sure if that's just like a generic false ID case or not, but multiple felons out of Texas. I'm not sure how long he's been in Michigan. He has no current cases out of Michigan that I'm aware of. His criminal history, he has assault from 2019 out of Parkwood Woods, which looks like it was deferred as assaulting a public officer or obstructing, where he got served 9 days ago. And that is it out of Michigan.
Anything further?
So I would also ask that he not be allowed to return to any public or private pools in the city of Royal Oak or parks, grass areas adjacent to it. Or have that.
Thank you very much. Mr. Angot.
Judge, as noted by the court, the presumption of innocence is absolute at this point. And so we must start from there. Mr. Stringer, or the person purporting to represent Mr. Stringer, is a business owner. Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
And there it is, the classic sovereign citizen pivot. Instead of answering the court directly, he reframes himself as a beneficiary separate from L. Stringer. This is a common tactic rooted in the strawman theory, the belief that the legal name in all caps is some corporate fiction. The problem? Courts across the country, including here in Michigan, have consistently rejected this argument as legally meaningless. Notice how calm the judge remains. No debate. No emotional reaction. Just procedural continuation. That's intentional. Judges don't validate pseudo-legal arguments by engaging with them. They simply proceed as if the nonsense was never said. And here's what's important. At arraignment, identity games don't derail the charge. The court has a body in custody, a case number, and jurisdiction established. The script doesn't change just because the defendant refuses to identify.
Thank you very much. The following conditions will apply to Mr. Stringer's release. Mr. Stringer will appear for all his future dates as directed. He will abide any valid order or judgment entered in this case. Mr. Stringer, you will not leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. You will notify the court in writing of any change of address, telephone, or email. Mr. Stringer will be making reports to pretrial services, and they will supervise his release. There will be no use of alcohol, marijuana, or any other controlled substance without a valid prescription from a treating physician, and Mr. Stringer will abide a substance abuse testing and monitoring program. No purchase or possession of a firearm or other deadly weapon. Mr. Stringer shall not harass, intimidate, beat, wound, or threaten Linda Marino and Chad Stransky, nor will he cause, through himself or through any third party, to have direct or indirect contact with said individuals. Mr. Stringer will not enter the cities of Royal Oak or Berkeley except for court, work, or medical treatment. And at this time, there will be 2 ETGs per week for control alcohol consumption and 3 controlled substance tests a month. Given everything that's before the court at this time, the court will set bond in the amount of $50,000 cash or surety, no 10% allowed at this time. If Mr. Stringer wishes to bring various motions before the examining judge, and that could include a motion to modify his bond, that is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on with what is going on right now?
I'm sorry, sir?
I'm being charged. I'm being charged an entity that is.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
Now let's pause on something bigger here. The charges aren't traffic violations. This isn't driving without a license or expired plates. This is indecent exposure, potentially a Tier 1 sex offense under Michigan's registry laws. That's serious. The judge carefully outlines the tier system under Michigan law. That's not casual language, that's long-term consequence territory. Registry requirements, DNA collection, prison exposure. And yet, instead of addressing the gravity of that reality, the defendant is still arguing about estates and beneficiaries. This disconnect is what often escalates sovereign citizen cases. The court is operating in statutory reality. The defendant is operating in internet mythology. And when those collide, procedure always wins. But things are about to get even heavier, because wait until you hear about his out-of-state history.
Len Stringer, 24-01173.
Good morning, Your Honor. Samira Malus on behalf of the people.
Good morning, Judge. For the record, David M. Sunutko appearing on behalf of Mr. Stringer.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Len Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
A living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. I have an individual before me that is listed as an Oakland County Jail inmate by the name of Len Stringer. I have a case that's been assigned to this court that where the defendant's name is Len Stringer. Mr. Sunutko, are you assigned on this case?
I am, Judge.
Okay, and you were assigned to the Stringer case, correct?
That's correct, Judge.
Okay, so that's enough for me to conduct this hearing today. Now let's walk through this. Miss Mount Lewis, have you provided discovery to Mr. Sunutko?
Your Honor, I didn't have an attorney listed. I believe if he filed, he may have just received written discovery. I didn't have that in my information, but give me 1 second to confirm. I'm just going to make one click.
In the meantime,
I do have written discovery, Judge.
So yeah, it sees that he was provided with written discovery on June 26th.
Okay, so Mr. Sunutko, have you had a chance to talk to the defendant at all?
I did, Judge. I met with him at the Oakland County Jail.
All right, and so
Tuesday.
So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
Okay, this is where bond becomes a real issue. 2 active Texas warrants, assault and family violence, a history dating back nearly a decade, weapons charges, evading arrest, impeding breath, which often signals strangulation in domestic cases. That's not minor. Bond isn't punishment. The judge even states that clearly. Bond is about 2 things: ensuring return to court and protecting the public. When you have a defendant with violent history, open warrants, and now a public indecency charge, that calculus changes. Notice something else. The defense requests a personal bond with GPS tether. That's strategic. They're arguing supervision can replace cash security. But here's the elephant in the room. How do you grant a PR bond to someone who won't even acknowledge the court's authority?
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Montlewis, can you prepare an order for competency review?
Yes, Your Honor.
All right. I agree. I think that that's appropriate at this time. I recognize that the defendant has made a request to have Mr. Sunuko removed from the case based on the information, though, that I've sort of observed at this time, as well as information received by Mr. Sunuko. I remain unconvinced that those statements are anything other than a manifestation of what might be a competency issue.
$5,000 cash or surety. No 10%. Translation? He cannot walk out with just $500 posted. This is intentional. The judge balanced the seriousness of the allegations, his history, and public safety concerns, and decided partial unsecured release wasn't appropriate. And notice the structured conditions. No alcohol, no weapons, substance testing, no contact orders, geographic exclusions from Royal Oak and Berkeley. That's tight supervision. Bond hearings are often where sovereign citizens expect dramatic wins. Instead, they usually encounter reality. The court isn't debating metaphysics, it's assessing risk. Now listen closely to what he says next, because it perfectly encapsulates the mindset we've been watching unfold.
And so I'm gonna wait to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sunuko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What labels me incompetent? My intelligence, because I have a high IQ?
We're about to go to war. That line tells you everything. This isn't someone approaching court strategically, it's someone framing legal proceedings as combat. And that mindset is dangerous for defendants. Court is not a battlefield. It's structured procedure governed by rules. The judge's response? Jurisdiction has been established by sworn testimony. That's the mic drop. Courts derive authority from law and process, not consent from defendants. You don't get to opt out like a gym membership. And now we transition to Judge Minnie, where the tone shifts from procedural firmness to psychological evaluation. Because when a defendant repeatedly rejects identity, counsel, and jurisdiction, the court has to ask a different question. Is this defiance, or is this competency?
No. That's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability.
Nature of the proceedings.
That you have the ability to assist your attorney in your defense.
To withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father, and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number, and he did not do that. So I would like him to withdraw from my case, sir. I have no. So he isn't competent enough for me, honestly.
This is the pivotal moment of the entire case. The defense attorney, after meeting him and speaking with family, requests a competency evaluation. That's not a small move. That's an officer of the court saying, we need to determine whether my client understands what's happening. Competency isn't about IQ. It's about functional ability. Can the defendant understand the charges? Can he assist counsel? Can he grasp courtroom procedure? That's the legal test. And the judge handles this correctly. If he allowed self-representation now and later competency was disproven, any conviction could be overturned on due process grounds. That's constitutional territory. So this isn't the court mocking him. This is the court protecting the integrity of the process, and ironically, protecting the defendant's rights.
So I do have, in addition to the information that's been provided, I have a recommendation for pretrial services that suggests that there are untreated mental health concerns, and the nature of his criminal history and criminal contacts suggests that there may be significant mental health, untreated mental health issues. So, Mr. Stringer, I've heard your concern at this time. I'm not going to grant your request until I get a better idea of what your current mental health status is. So the request at this time is denied, but I will consider it again after an evaluation is done.
Hey, so who is the judge on my mental health? Because you can't obviously be a judge because, sir, I'm with my law, sir. So first off, I do not acknowledge myself to be Lindell Stringer, the corporation in capital letters. No, sir.
And that's where we leave it. Not with a sovereign citizen victory, not with a dramatic courtroom collapse, but with a competency evaluation order. Point two judges handled this case with precision. The first focused on jurisdiction, bond, and public safety. The second recognized that something deeper might be at play and ordered a forensic evaluation before proceeding further. That's how the system is supposed to work. This case highlights an important distinction. Unconventional beliefs don't automatically equal incompetence. But when those beliefs interfere with understanding charges, communicating with counsel, or grasping reality inside a courtroom, the court must intervene. Whether this ends in trial, plea, or treatment depends entirely on that evaluation. But one thing is clear. Internet legal theories do not override statutory law.
I appreciate that, and that's why I let you make a record, and I appreciate that. I just, based on what I've seen, I disagree with your position right now, and we'll get you evaluated.
You cannot.
That's enough for now, and then we'll have you evaluated by the evaluated by the forensic center, and we'll go from there. Thank you, Mr. Zanuko. Bond is continued.
Do we have a new date, Judge?
We'll set it 90 days out.
Very good. Thank you, Judge.
Thank you.